Hello, friends. I welcome you all to this 35th session of Law of Evidence. And today we are going to start with chapter 6, which deals of exclusion of oral by documentary evidence. So, the chapter's name is chapter 6, and it is of the exclusion of oral by documentary evidence. That is, wherever documentary evidence is there, then preference will be given to documentary evidence as compared to the oral evidence. Or wherever there is a documentary evidence, the oral evidence will not be allowed. Now, this is a part of the three cardinal rules that we studied at the very beginning. That is the three cardinal rules. I will just say once again that the evidence must be confined to the matter in issue. That is, only those things which are relevant should be brought forth. Second is that the evidence should be direct. That is, hearsay evidence must be avoided. Except in certain circumstances, hearsay evidence should not be admitted. And third is that best evidence rule. What does this rule, best evidence rule, says is that the party should give the best evidence in possession to prove a fact. That is, the evidence that will be most suited, that will bring clearly out his point of or his contention, should be given by the party. So this chapter 6 is based on this best evidence rule, and it starts with a brief overview of it is that how evidence of terms of contract reduced to document are required to be proved. For if there is a terms and conditions of a contract which has been written out, it has been executed by both the parties. Now, how they are to be proved in court of law. Now, here is there chapter 6, section 91 comes into play. What it says is that evidence of terms of contract, grants, and other disposition of property reduced to form of document. So it relates to the terms of like a contract or grant or disposition of property which has been done through a doc or which has been documented. When terms of contract, of grants, or any other disposition of property have been reduced to the form of document. So, a document has been made for the contract, grant, or disposition of property, and in all cases in which any matter is required by law to be reduced to the form of a document, and in which cases it is compulsory by law or law has made it mandatory that it has to be in form of a document. No evidence shall be given in proof of the term of such contract, grant, or disposition of property except the document itself. That is, if these two conditions, that is, it has been a document has been made and it contains the terms of these three things, then only and only the document will be allowed to be given in proof, whether it be primary or secondary as the conditions may be. or secondary evidence of contract in case in which secondary evidence is admissible under the provision hereinafter contained. So, what it says is that basically there are two types of document this section refers to. What are the two types of document this section refers to? One, voluntarily that has been reduced to writing, and another compulsory, that is by law it is to be reduced in writing. So, a document has been formed whether voluntary or compulsory. Now, if this thing has been done, then it can, the proof of such document is to be given only by primary or secondary evidence and by no other means. So, where registration of document is compulsory, if registration has been made compulsory by law, then no, only registered document will be admissible in such case, and unregistered will be inadmissible. Now, it has got two exceptions attached to it and three explanations attached to it. We will see one by one what are those. So, let us see exceptions. When a public officer is required by law to be appointed in writing. So, where a public officer is appointed in writing, and when it is shown that any particular person has acted as such officer, and it is shown that that person is acting as such officer, the writing by which he is appointed did not be proved. So, where a public officer is required to be appointed by law and that person has been acting as such, then it is not necessary for him to produce the appointment letter every time. So, if there is a question that whether a person is a high court judge or not, then he is appointed by warrant appointment. He did not carry the warrant of appointment every time. The only fact that he is working as high court judge will be sufficient proof in this case. Then exception 2 says wills admitted to probate in India may be proved by probate. So, if there is a probate means many a times it is asked in interview. So, please remember probate means a copy of will certified by court of competent jurisdiction. So, if a will has been certified by court of competent jurisdiction, then it becomes a probate. Now, the probate is sufficient and one need not always carry the will as such. Then it has got three explanations attached to it. First explanation is that this section applies equally to case in which contracts, grants or disposition of property referred to are contained in one document and to cases in which they are contained in more documents than one. So, if the contract is made in one document or it is made in multiple document, then then the multiple document has to be proved, and says that where there are more original than one, the second explanation says that where there are more original than one, then only one original need to be proved. So, if the document is made in three original copies, then it is not necessary to produce all the three original copies, only one will be more than sufficient. For exception, for explanation 1, that is when it is contained in more than one document, as illustration A, that if a contract be contained in several letters, so there are several letters in which the contract is contained, all the letters in which it is contained must be proved. So the same contract, this is explanation 2. If the same contract is contained in several letter, part in this letter, part in letter 2, part then concluding part in letter 3, then all of this has to be proved as such. Now to explanation, this is to explanation number 1, that is when it is in more the document or contract is in more than one document. Now to explanation 2 is illustration B, that is where there are more than one original, only one original needs to be proved. So if a contract is contained in a bill of exchange, the bill of exchange may be proved. If a bill of exchange is drawn in a set of 3, so 3 sets of bill of exchange has been drawn, then only one needs to be proved. So it is not necessary to prove all the 3, proving one will be sufficient as such. Now explanation 3 says the statement in any document, whatever of a fact other than the fact referred to in this section shall not preclude the admission of oral evidence as to same fact. Now suppose there is a document and that document contains terms of contract and other things which are not related to this contract, then for proving this other things the oral evidence can be given. This section 91 will apply only with respect to the terms of contract, disposition of property and grants. So a contract in writing with A contracts in writing with B for delivery of indigo upon certain terms. So A and B makes this contract for delivery of indigo on certain terms. The contract mentions the fact that B had paid A the price of other indigo contracted for verbally on other occasions. So it contains some other fact also that for from previous transaction payment has been made. So this fact can be proved by oral evidence, but the terms of the contract cannot be proved, though both of them are contained in the same document. So that is what is section 91. And please remember, many a time it has been referred that section 91 refers to, it refers to bilateral agreement, because whenever a contract will be made, it has to be two parties as such. Many a times in pre it has been asked. So just a revision of what is contained in section 91, that if a document whether voluntarily or compulsorily by law has been reduced into writing, then it has to be proved by writing. Exception says that public officer need not show their appointment letter every time. For a will, the probate, you need not carry the will. And explanation, three explanations are there. First explanation says that if it is contained in more than one document, then all the documents are to be produced. Explanation 2 says that if there is more than one original, then only one needs to be proved. Explanation 3 says that the condition under section 91 refers only to terms of contract, grants and disposition of property. For other matters contained in the document, proof can be given. So that's all. Thank you, friends.